Good afternoon, everybody. My name is Hussein Mahadi, and I'll be the moderator for today's session on the first week of the first quarter of 2023 on Jiipcc Mentorship and Internship Program for Intellectual Property. And our topic for today is intellectual property for business. I'm so happy to see you all on this call. Those of us that are still joining, please be on a good network reception. You are all advised to put on your videos. Our mentorship session is being live streamed. And we'll be having two mentors with us today that will be discussing the topic for today. So sit back, sit tight, and be ready for a, what is it called? Help me with the word. I just forgot that very good vocabulary I want to use there. It's going to be a very entertaining and let's say enlightening session.
Entertaining and informative.
Okay, informative and enlightening session today. So the first mentor for today is Ms. Amosa Shukrat Modupeola, and the second mentor is Mr. Max Ikombe. So quickly before we move to our mentors presentation, I think they are not here with us yet, but they will be joining us very soon. I just want to know how we are all doing. I can see Faith on the call. Faith, how are you doing? I can see Bushra Gazelle. How are you doing? I can see Enifilma. God's love. I just saw this man some hours ago on another call. How are you doing? I can see Ibembo. I can see Hawao.
I'm fine, thank you, sir.
Grace, Ayodeji, Debere Chuku, and the rest. If I can't call you, please, I'm sorry. I see you all. So please kindly put on your videos and be ready for our mentors. So quickly, I'll be taking some announcements and telling us what Jiipcc Mentorship and Internship Program is all about. Kindly follow up as I share my screen. So Jiipcc Mentorship and Internship Program is a quarterly program for students and young professionals across Africa. Mentees are afforded the opportunity to access valuable advice, training, network, mentorship, internship, discussion forums, industry updates, and resource materials from experienced mentors. The program seeks to encourage continuous training, development, and evolution in Africa and around the world. You can watch our videos by searching for Jiipcc on YouTube and Facebook, #JiipcCMIP. And some of the objectives of the program is to provide easy access to quality professional guidance, training, and resource materials for students and young professionals in Africa, to facilitate dialogue and network among experienced and less experienced practitioners and stakeholders, to transform mentees into mentors and leaders for the next generation, and finally to facilitate further mentorship, internship, scholarship, and job placements for the mentees. So that's what Jiipcc is all about, and I'll be taking a few announcements before as our mentors join us. So quickly, Jiipcc Mentorship and Internship Program the registration is still currently ongoing. This is just the first week, so anybody interested can still hop on the bus, or you can also share the links with those that are also interested in the next quarter of Jiipcc Mentorship session, which is after the 9 week of this program. So you can share the link. The link is always on your group chat. We have courses like intellectual property, artificial intelligence, energy industry, fintech, health tech and law, patent drafting, and blockchain, NFTs, and metaverse. Quickly again, we are all entitled to a private one-on-one session with your favorite mentor on the Jiipcc Mentorship and Internship Program. So you can also register for that by clicking on the link bit.ly/Jiipcc PM, or sending me a DM, or sending the Ms. Juliana or Mr. Joe a DM. Okay, that will be that for the announcements for today. I'll quickly be reading the profile of Mr. Max Ikombe, our first mentor, and also Ms. Amosa Shukrat, our second mentor for today. So Max Ikombe is the founder or principal of Ever Law Associates. They work extensively in the field of arbitration, ICT technology law, and intellectual property. Max is a facilitator on the annual Information Technology and the Law course of Nigerian Institute of Advanced Legal Studies since 2016. He has trained in advanced intellectual property law course at the World Intellectual Property Organization Academy, and he is an accredited agent of the Nigerian Trademark and Patent Registry and has conducted IP registration business there since 2010. Thank you very much for all your good work, Mr. Marks, and we are so happy to have you here today to join us and give us some more lights and mentor us on the topic for today, intellectual property for business. I will also be reading our second mentor's profile quickly before we move forward. Ms. Amosa Shukrat Molukola is a proficient consultant, analyst, and educator in the field of intellectual property with public sector experience. She is a member of the World Intellectual Property Organization WIPO Committee and has a master's degree in intellectual property at Africa University Zimbabwe in conjunction with WIPO and Japan government. She has partaken in professional training at the World Intellectual Property Organization as well as other IP-related bodies and has facilitated numerous intellectual property-related programs, both online and offline. Shukrat is the pioneer of an educational platform, DIN, the Intangible Nuggets, which facilitates IP awareness and brings the knowledge of intellectual property closer to everyone. In celebration of the 2022 World IP Day, she partnered with other stakeholders to sponsor 5 IP enthusiasts and register them for WIPO advanced courses. Amosa is an accredited agent at the Nigerian Intellectual Property Office, Nigerian Copyright Commission, Trademark, Patent and Design Registry. And her expertise are but not limited to trademark, patents, industrial design, copyrights, trade secrets, respectively. Thank you very much for joining us today, Ms. Amosa Shukrat Ola. So quickly, I can see Mr. Marks is on the call with us, so I'll be calling on Mr. Marks to start with the lecture for today and tell us more about intellectual property for business.
Okay, good afternoon, everyone. I hope you can hear me.
Yes, sir, we can hear you loud and clearly.
Okay, thank you, everyone. It's, of course, always a privilege to be on the Jiipcc platform. Of course, I must always start by thanking the founder and convener, Juliana Imam, and of course, I thank also the moderator, my fellow mentor for today, Ms. Amosa, who is, I believe all of you would be delighted to get to meet. She's indeed one of the powerhouses of IP, and especially when one considers that she's not necessarily a lawyer, but she's made so much strides in the IP space. And then indeed, that is what IP should be really. IP is not a field exclusively meant for lawyers or for people who have necessarily a legal background. IP is actually a business phenomenon, which now takes me to the topic for today. So yeah, when we talk about IP and businesses, you know, I think what had happened before now for a long time is that people really underestimated the importance of IP to businesses. And it is necessarily so because IP as a discipline developed as an aspect of law, even though an aspect of commercial and business law. But invariably, over time, IP developed as a subset of business law, related to dispute resolution, not necessarily as a transactional part of business. So because of that, there was some disconnect between the usefulness of IP as an aspect of law and the usefulness of IP as a management tool, as an equipment that a business would use to enhance its business. But over the years, of course, that has changed. In the economies, that changed a lot faster, but maybe it took a little longer for that change to happen in places like Nigeria, but it's happening now. So with people like Amusa, whom you would have the privilege of listening to soon, you see that these are people who are taking IP outside of the courtroom, outside of disputes only, to now look at IP in context of what IP should be doing in a business. Disputes is only a small fraction. I mean, a business that gets it right, IP as an enabler for resolving disputes should be less than 5% of what IP is doing for a business. IP has a lot more that it should be doing in a business, much more than just resolving disputes. So, I mean, for those who are lawyers or who are familiar with, law, there's something we say about certain principles in law, like estoppel. You'd say estoppel is a shield. It's a shield and not a sword. What that simply means is that there are some principles of law that you only use to protect yourself. You cannot use them to go on the offensive. But IP actually was thought of that way for a long time, that IP is something you should defend yourself against maybe counterfeiters, against people who want to come and make use of your intellectual property without paying you, returns for using the property. But over time, the understanding of IP has gone beyond that. IP now is also an active tool that you can use to make money. So it's beyond just protecting yourself. It's also something you can use to make money for your business. You can use to grow your business. You can use to grow profitability. You can use to expand your business. And I'll try to give a few examples of how that works out in practice. Of course, we know the traditional role of IP, and I've seen some of the presentations and they capture them very well. So you could register your inventions so that way nobody else can use that invention. That's a patent. Nobody else can use it without getting a license from you. You could register your unique brand assets, your logo, your name, your tagline, and other things. And that way nobody can use those brand assets to market their own products. And that would also ensure that if counterfeiters want to use it to market their brand products, you can go to court, get an injunction, get damages against them. Now, these are the traditional uses. Copyright is also the same thing. It's the right to protect the economic exploitation of creative works. So this could involve literary works, drama, plays, movies. It could include things like artistic works, works of sculpture, drawings, paintings, and so many other things that copyright covers. There's also industrial designs. You could also use, digital design to protect that unique aesthetic features, the features that make your product catchy to the eye and attract customers to them. Of course, these four I've mentioned are the traditional intellectual property types. You have even the unconventional ones, things like trade secrets, protection of unregistered trademarks using the law of tort in terms of passing off. These are other ways you could protect your intellectual property. But you can see that all I've mentioned now are more or less the defensive use of intellectual property. But businesses have now realized that beyond just using them to protect yourself against third parties, you could also actually use it to collaborate with people. So you now begin to look at things like licensing, assignment, and all of that. And these are ways to unlock value from your assets. So for instance, we are all most of us are in Nigeria. You are aware that there are a lot of these brands. KFC, for instance, is a US brand that now has outlets in Nigeria. So what's happening essentially is that KFC has now got to look, apart from the US, that's our primary market, Nigerians also like our products. We want to make our products available to Nigerians. How do we do that? They now try to license their trademarks and other intellectual property rights under a franchising agreement. So you can see that they are now making money from Nigeria, where they do not have, the traditional market to get into really, because they are a US-based company. But they can extend their reach and make money from Nigeria by licensing a third party under a franchise agreement to exploit their brand in Nigeria. So you can see how IP has now gone beyond just protecting themselves to collaborating with a third party who would have been a counterfeiter and an infringer, infringing on their goods in Nigeria, to now say, look, let's make money from you rather than you being an infringer. So you can see how IP has extended. Now, as I round up, this is, like I said, and things I've said just to give you an idea of how IP has evolved from merely being protective to also become a tool to enable businesses to make more money. I know one of your presentation covers this, and I read it in advance, and I think you've done a great job. But yesterday I was listening to a webinar by a fashion brand, the intellectual property, the anti-counterfeiting coordinator of that brand was saying that apart from the traditional harm that counterfeiters cause to their business, they found out another way that counterfeiting was impacting their business was this. Now, they have customer care lines that people call when they order products and there are issues. They now found out that because at a point in time in their business, they were not checking counterfeiters. A lot of counterfeiters opened fake websites and were selling counterfeit products, or or even passing off as the company and collecting money from people and not delivering the goods to them. So what that did to them was that apart from losing revenue from those sales that this counterfeiter had monopolized, they now found out that a lot of those disgruntled customers will now call their customer care line to report that, look, I ordered the product from your website 3 weeks ago, I've not gotten the product. Or I ordered the product from your website 3 weeks ago, the product that came to me is substandard. By the time those customers call their customer care line, those guys will now keep their customer care line engaged. And when real customers who had real needs call that same customer care line, they'll not be able to get across. So you can see now that two things were happening to them now. They were losing revenue, and then now real customers who had bought from them could not reach them. And they were now losing those customers as well. So you can see how dangerous, if you do not protect your intellectual property as a business, how dangerous it can be for you. Beyond losing revenue, you begin to lose customers, your brand reputation gets completely damaged. So this just gives you a quick snapshot of how important intellectual property is to businesses and why businesses must protect their intellectual property, and why it's important that as a lawyer or an IP practitioner, you don't only come from the viewpoint of register your products and protect yourself. You go beyond that and show businesses how not registering and protecting can impact on their profitability and their growth as a business. So there's so much more that IP can do for businesses, and it is your responsibility as an IP practitioner to open their eyes to these realities and help them maximize returns on their investment. So with this, I'll stop at this point, and of course, after your presentations, we'll come back to review them. Thank you very much. Back to you, moderator.
Thank you very much, Mr. Marks, for the enlightening speech and lecture. We'll be taking that of Ms. Shukrat Amosat now. Ms. Shukrat, please, you can unmute yourself. I think I saw a meeting some minutes ago.
Yeah, I'm available. I hope it's clear. Yeah, good evening. Can you hear me?
Yes, we can hear you.
Okay,
Yes,
okay.
I can hear you, ma.
To share my slide briefly, I prepared something. Then we can go ahead. Okay. Please let me know when you can see my screen. Still coming up. Okay, I think it's up now. So can you see my screen?
It's loading.
It's loading.
Okay, yeah, we can see it now.
We can.
You can. Okay. So welcome to another session of the Jiipcc. My name is Amosa Shukrat, like Mr. Marks has said. Mr. Marks is my older, I don't mind him. So basically, Mr. Marks has talked about IP generally, but I'm just going to talk about this as well. So when you have an intellectual property, the end game is not just protection. It doesn't end at protecting your IP. There are so many things you can do with your IP. And I've gone through the materials as well. I can see the other group wrote about how you can monetize, license, franchise, and the like. So when you have an intellectual property, we say intellectual property is the creation of our mind. So it is not just limited to idea. And when you say idea, most people feel like idea is just for copyright alone. Idea could be anything. You can have an idea of, okay, fine, this is how I want my trademark to look like, or this is how I want this invention. I have an idea of an invention. So idea could be anything, basically, not just copyrighted work alone. So when you now have an intellectual property, what do you do to this intellectual property? The first thing you have to do is you have to create it. You can't have an idea in your head and say you have an intellectual property. Without creating, there is no intellectual property. So you have to create it first. Once you have created it, what next? You have to register it. Although not all intellectual property require registration, like copyright doesn't actually require registration like that. But on the long run, we still have advice to copyright it in case of enforcement, and somebody infringe on your copyright and you want to enforce. You'll be asked to show a proof of ownership. So we always advise to register. Once you are registering, what next? You don't end at registration. Most people just end at number 2. Once they create and they register it, then that's all. You have to police it. Nobody is going to police your IP for you. You can't be charging your phone somewhere and you go for 1 hour and don't check back what exactly is on your phone, where your phone is. You have to police it. Nobody is going to police, except you probably get one agency to monitor your brand for you, but you are your first police. You have to police your brand. Once you now police your brand and you find out that somebody has been infringing on your brand, what next do you have to do? You have to enforce your rights. Once you police, you have to enforce. Don't say, oh, we are in Nigeria, before the court we do this and that. At least put a foot forward. People are getting damages, they're seeking damages now, and it might take long to get something out of it. So when you police and you find someone infringing, you have to enforce. Once you are done with all these things, what else do? You have to monetize. Like people will say, oh, Nikoko, like what's the benefit of an IP that you can't even monetize? Just have an intellectual property and put it in your wardrobe. It's not making money for you. So what is the essence? You have to monetize it. How do you monetize? License, franchise, co-branding, cross-licensing. Just make sure you're making money from it. Or you just sell it outrightly. Assignment, transfer of rights. Once you monetize it, now what do you have to do? You have to use it. Most people just register their trademark. They don't use it. Some people will just register a patent. You don't work that patent. It's just there. You have a certificate in your cabinet. You are not talking to investors. Oh, I have a patent. I want to license it to you. Or this is how we can work on this patent. So after 20 years, it expires and you don't get any money for the invention you have done. So you have to use it. If it's your trademark, you have to use it. When you don't use your trademark, it can be revoked and given back to somebody else. Don't say you're not going to return your money for registration. No, I was having an argument with a colleague of mine about the same use, that if you don't use your trademark, somebody else, you can revoke it. And she was like, okay, fine. So the person that now wants to register is supposed to give you money for registration. I'm like, no, you've registered, that money is gone. The person will not give you the money that you used to register. It doesn't work that way. If you don't use it, it's gone. So you have to make sure you use your trademark. If you don't use your trademark, it can be revoked due to non-use. So how do you create intellectual property? So if you are following me on LinkedIn, you'll find this slide. So I just said to talk about it a bit. So once you create, there is no such thing as protection of an idea without first creating it. For this reason, every intellectual property has to be created before it can be afforded any type of protection. You have to create. Your idea cannot be protected. So the next thing is you register it. How do you register? When it comes to property in general, be it tangible or intangible, protection is paramount, and as such, there is need to protect your intellectual property by registering it with the appropriate intellectual property office. The next one is the policing. I said, even when you know your IP right is yours and yours alone, it is required that you police it. That you police it the way you police your babe to avoid stories that touch. So most of the guys. Yes, most of the guys here know. Even when your babes love you or you love your baby, you still kind of police her around. So do the same thing to your brand. So monetize it. Repeat after me. Oh, Nikoko, yes. Money stop nonsense. But what is the essence of an asset that you cannot monetize? And the last one is use it or work it. Lastly, if you desire to continuously make money off your IP, pending the time it goes in the public domain, get ready to put it on your head and hawk it shamelessly. Just like the way Don Jazzy is hawking his Jazzy burger. You need to see someone like Don Jazzy, if he can still put his Jazzy burger on his head and still hawk it, despite the fact that he has, you know. So once it's just you, an upcoming artist or a new business owner, now you can't do all of these things. And the last one says, protecting and monetizing your intellectual property is a new flex. Seriously, this is just a new flex, basically. So that's what this slide is all about. And we'll go back to this one now. So this is just an overview of IP. So it's IP for business. Now look at this first one now. Let's assume this is a person, a business owner that has a business idea in his or her head. So you can see the idea inside the person's brain, just sitting down there, right? And the next slide, you can see the business owner trying to express this idea. And you can see someone there at the back trying to steal the idea, right? Now look at the next image. Now they are fighting over the idea. It's my own, it's my own, it's my own, it's my own. Just because while expressing, somebody saw you doing that. The next phase here, this person has an idea of, fine, let me just protect my idea so that other people won't come, like this third guy here trying to drag my idea with me. So after the person must have protected the idea, look at the last one here, exchanging the idea for money, you are monetizing it. So that's just the overview of IP basically. You have an idea, you express the idea, you protect it, and you monetize. Don't stop at protection. When you stop at protection, it's just there. You're not using it for anything. So why will you have something? It's just like, fine, you have something, you're not using it, but I'm in need of it. So I should be able to like revoke whatever it is you're not using and get ownership over it. And that was what happened between Apple and so is this Swatch also? Yeah. So you have to use your intellectual property. Make sure you are using it very well. Mr. Max has said majority of all of these things. Originality, I said originality is the yardstick used in evaluating creativity. So a sufficient amount of intellectual creativity should go into the process of creating any work. So most people are like, you have a, and we should also understand that there's difference between imitation and, what do you call it now? Imitation and inspiration. Most times you are inspired by somebody's work, but you copy the exact same work. So how are we going to know your own work is original? There's no element of originality in that work. So even most times, all these things we are saying, they are out there. But the way I express myself is different from the way Mr. Max is going to express himself. And that's where the originality lies. So you should be able to know how to actually make yourself original. So when they see my post, like, oh no, this is Amosa's post. This one, no, this is Mr. Max. This is how he explains himself. This is how Amosa does her own. This is how Juliana does her own. So that's where the originality lies. But the same idea, we still have the same idea. We are just expressing it in different ways. So originality can be as simple as telling the story behind the shot, creating a brand or a unique fashion sense. So these are the types of intellectual property. So I once asked the question, I said, intellectual property is broadly classified into how many? And people actually got that answer wrong because IP is generally or broadly classified into two. We have the industrial property and we have copyright. So other industrial property, we now have patent, trademark, industrial design, trade secret, TKH, graphical indication, and the likes. Why copyright is just standing on its own, like we have our NCC standing on its own. Do you understand? So IP is broadly categorized into two, industrial property and copyright. Under industrial property, we now have this IP that we know about. So types of intellectual property. You see this book here that is changed kind of. So that's why we have copyright. Copyright expresses, protects literary and artistic work. Then you see this other channel, whenever you see a logo like this, notice this channel's logo. So that's its trademark. Trademark identifies and protects, identifies and distinguishes the brand of a competitor from that of others. When a trademark does not identify and distinguish, it is no longer a trademark. And that's why we say generic mark and not trademark. Because when you have a generic mark, like let's say, what's that generic? Close up. I want to buy close up. Your intention is not to buy close up. You might just say, maybe you wanted to buy my mind, but you said I want to buy close up. But we've now generalized all McLean as close up. So that is now generic because that close up is no longer identifying the product of close up itself. It is now used to generalize all the products. Or when you say, I want to buy biro, there are different types of biro. There's Lucky Cora, there's Cora Lucky, there's Lucky Cora, Cora Lucky, and so on and so forth. But when you say you want to buy biro, are you buying the person that created biro? Because the person that actually created biro is, there are two brothers, Big and Biro. So you can't say you want to buy biro. The moment your trademark does not identify and distinguish your brand any longer, it's no longer a trademark. Then patent, you see this kind of research, kind of, so that's what patents protect. And I say it all the time, patent is not all about machines and anions and cations. It could be something as simple as putting a straw in a bottled water to make it easier for you to drink water. And what does that do? It solves the problem of spillage while you are driving. So your patent should actually solve a particular problem or provide a new way of doing something. Like someone created a cream whereby in that village, they don't have water. So you might not have bathed for like 3 days, but once you just drop that cream, you'll be smelling all fresh and nice. That's an invention. As long as they are solving a problem or providing a new way of doing something, you can get a patent for it. Then this last one here, this beautiful chair is industrial design. You can prove, you and your competitors can sell the same product, but the way you package your product can make you have more sales compared to your competitor. So there used to be these guys that sells popcorn. So now there are two guys. They sell popcorn just by their size, two of them. But one other guy thought of a plan that, okay, fine, I want to be adding stickers on my own popcorn. Why the other guy does not add sticker on his popcorn? But this guy with stickers sold more. Because children are like, oh, this is my sticker. I'll show my friend when I get to school. I have this sticker. Which sticker do you have? So because of that sticker, they purchase from that guy that sells sticker. But both of them sell popcorn. The only difference is one has sticker and one does not have sticker. So how you package yourself really matters. Then this one is your trade secrets. Either you keep quiet or you sign a non-disclosure agreement with whoever it is you are giving your trade secret out to. So depending on the type of business you are doing, that is why you know which of these IP applies to you. If you are someone, if you are an inventor, you should know fine, you're going to have a patent. And it's possible you can have all of these IP in one single object. It's possible. It's very possible. Look at Coca-Cola. They have the trade secrets. They have their brand name. They don't have patent. They have trade secrets instead. They have the industrial design, although industrial design can actually be substituted for trademark because, and again, you have to look at the length of protection. It matters. Now, let's assume Coca-Cola had gone for patents instead of trade secrets. Where would they be today? Their secrets would have been in the public domain and everybody will be producing Coca-Cola by now. So you have to think about that. Number two, let's assume their Coca-Cola bottle, they actually went for industrial design instead of trademark. That design will be out by now and everybody can use it. So you have to look at the kind of business you are doing. What exactly, are you looking at a long-term protection or a short-term protection? Do you understand? So you can't say, okay, fine. Let's assume you are in an industry that things keep evolving, like patents. People keep building something and building something. So after that 20 years, the patent is going to just elapse. We were having a discussion yesterday and some of my classmates were like, 20 years is too long for patents, that we should have something lesser, like maybe 10 years or 12 or 15 years, because people keep inventing. And people also go for this process of evergreening. Once your patent is about to expire, then they just update it or upgrade it and just file another patent. So it doesn't really, once it's 20 years, you have a new one to protect as well. So we were like, okay, fine. If you say you should give them 20 years or lower the years, it means about the work they've done. And most patents, sometimes it's 3 years before they grant it. And that time is already, they'll count that time because your time is counting after you must have filed, not when it was granted. So you have to put all of this in consideration. So are you looking at trade secret or patent? Which one is better for your business? Industrial design or trademark? Which one is better for your business? Copyright or industrial design? Which one is better for your business? So you have to look at it very well based on the type of business you are doing. So I think I'm just going to stop there and let the presenters to take over. Thank you.
can you help me with what is already done?
Thank you very much, Ms. Shukrat Amosa. I'll be calling on our presenter for Group 1 to make their presentation. We have two groups, so we'll take Group 1's presentation. You have 10 minutes to make your presentation and share your PowerPoint slides, and Group 2 also have 10 minutes. So Group 1 presenter, I hope you are ready.
Yeah, I'm ready.
Okay, thank you very much.
Good evening, everybody.
Good evening.
Can you not hear me?
Hello, good evening. Can you hear me
Yes.
clearly?
My name is Enifume.
So is it just me or I can't hear the presenter anymore?
I can't hear him also. Any former, we can't hear you, please. Is there a backup presenter? If Group 1's presenter is not ready, backup presenter for Group 1. Okay, while we are waiting for Group 1, Group 2 presenter, are you available? Are you ready?
Group 2, I'm ready.
All right.
Should I go on Group 2?
Yes, you can go on Group 2.
Okay.
You have 10 minutes.
Okay, I'm seeing that I can't share my screen while other participants are sharing.
Okay, hold on, I'm trying to share it now.
Okay, I can now. Let me just go on. Good evening. Can you hear me?
Yes, we can hear you. Your time is going on.
Okay, good evening. I'll be presenting for Group 2, and today I'm presenting on IP for businesses. So for the content we have IP licensing, IP franchising, IP export, IP management, IP assessment and valuation, trade secret or confidential information. So for this content, I think it is very important that we understand what we mean by IP commercialization, because it covers everything that I will be talking about. So what then is IP commercialization? IP commercialization may be defined as a process where IP assets are taken to the market. So they are not just taken to the market for taking sake, they are taken to the market to gain revenue or multiple revenue streams. So we also need to understand what we call IP monetization. IP monetization is the process of making money off your assets. And the kind of assets we're talking about are registered assets, IP assets like your trademarks, your copyright, your patents, and other IP assets like your trade secret or confidential information. So my name is Ayeni Faith. First, we'll be discussing on IP licensing. So a licensing agreement is an agreement between a licensor and a licensee. The licensor in this case is the owner of the IP asset, and the licensee is the person that is getting the IP license or asset from the licensor. A licensee pays the licensor to be able to use the IP asset. It is always in a written document, and it pays him what we call royalties that is agreed upon. We have two types of IP licensing. We have the exclusive license and non-exclusive license. So the exclusive license enables just that licensee to use the IP asset without even the licensor being able to control. So the basic thing that we should understand about licensing agreement is that there is not much control coming from the licensor's part, that's the owner of the IP asset, to the licensee, why the transaction or why the agreement subsists. I'll move to IP franchising next because it follows each other, and there's most times people try to mistake the two for each other. In a franchising agreement is an agreement between a franchisor and a franchisee. Just like IP licensing, a franchisor is the owner of the asset, while a franchisee is the one that pays to get the asset. Now, the major difference between the both that we should bear in mind is that why in a franchising agreement, there is the interdependence between the franchisor and the franchisee, because it controls the way the brand works. So in a licensing agreement, maybe just a part of the intellectual property, it could be the trademark, it could be the patent, just a part is being licensed out. In a franchising agreement, on the other hand, almost all the IP assets is given to the franchisee. So you must make sure that for as many franchising outlets, for example, that they have similarity in mode of operation. So for example, we have McDonald's, one of the biggest franchising, they have one of the biggest franchising agreements in the world, and they have 36 as we speak, they have about 36,000 restaurants. Sorry to stammer. They have about 36,000 restaurants where they do the same thing. So most times people think it is just one person that goes about from territory to territory building and doing all sorts, but they don't know that it is actually a franchising agreement. Whereas for the licensing, when there is a known brand, for example, Calvin Klein, Disney, they just work with manufacturers, different manufacturers that are in different fields. Some produce maybe jeans, perfumes, different clothes, wristwatches. So they use that name to sell, because it is kind of like an equity tax, building their own brand from the onset. And because the name is already big, they just go and get the licensing. I would move to, I'm sorry if I am not following, but I'll try to follow from now. I'll move to IP exports. So we should bear in mind that intellectual property most times is territorial in nature. So once a person that has an asset, for example, an IP asset, you protect their assets within the borders of their country. The protection does not go beyond that. Please, is anyone following?
Yes, we are.
Thank you. I'm sorry, I'm too fast. I'll just calm down because of time. So the protection does not go beyond the territory of their country. So if they intend at any point to make their brand, if they intend to take it to a foreign country, they have to understand that they have to develop international strategy to protect their IP outside the borders of their country. So by developing international strategy, we have they know their markets, the target market, the country, they develop their goals, their resources, and the rest. So sometimes they work with professionals in the field and they decide whether or not to file, depending on their budget, to file more than one, to file individually to different countries, or to file in form of like an international agreement at once to make a single application. So it should also be noted that the reason why studying about IP exports is important is that you need to know whether or not in the country you intend to take your market to, someone else has
protected their rights, and you don't want to infringe on their rights. And also for translation purposes, it is very important. I'm saying this because sometimes in the language you use, the language you speak in your country, it might be one way, but then when you go to the for registration in other countries, you need to translate, and translating fee is quite a lot. So sometimes the application gets accepted and it gets rejected depending on the country. Quickly, I'll go to trade secret and confidential information. It's actually trade secret or confidential information. Some jurisdiction call it either of the two. So Article 39 of the TRIPS agreement, that's the trade-related aspect of international property rights, talks about features of confidential information. And one, it must not be publicly known. One, and two, it must have economic benefit to the owner. And lastly, let me say reasonable step must be taken. Yes, reasonable step must be taken for its protection. So trade secrets include things like formulas, processes, compilation that creates and that gives economic benefit and shouldn't be known, because the moment it is known to the world, then it is no longer a secret. A secret is known to just limited people. So we have Coca-Cola secret, the formula for making the Coca-Cola drink. We have KFC, etc. A locus classicus for breach of confidence is the case of Coco against A.N. Clark. The test for action for breach of confidence. I'll move straight to intellectual property management. So intellectual property management is a process where business owners regulate their intangible assets. So it's a process where they create strategy for intellectual property rights capitalization. And by doing this, they have to develop IP strategy, which is like a company's plan of action to manage and protect its intangible assets in a way that aligns with the overall business strategy and goals. So your IP strategy must consist of three critical elements. That's the protection, you must protect your right; optimization, that's the use of it; and IP monetization. Lastly, I'll go straight to IP assessment and valuation. Valuation is a process to estimate the monetary value of your intellectual property rights, and method of estimating this IP value is the market method and the income method. The market method, basically, you estimate it by looking at similar assets and the prices for this similar asset. Or the income method, which is the most popularly used, you look at the future of the IP, and you can get the future of the IP by knowing the potential. Okay, what can this intellectual property bring in the nearest future? It is difficult to ascertain, but when you know the value of what you have, then you know that you can price it that way. I think with this, I've come to the end of the presentation. Thank you very much.
Thank you very much, Ayeni Faith. Personally, I think you did a very great job. Kudos to the team for putting up such a wonderful presentation. Thank you very much for also putting the time into consideration and being very brief. So I'll call on Group 1. Group 1, you can start your presentation. I learned that you were having network issues. So you can try again, maybe ask someone from your group to help you share your screen.
Good evening, everybody.
Good evening.
Okay, sorry for the breaking connection. Really sorry for that.
Please tell us your name. We are seeing numbers there.
Okay. My name is Enifome Ekwa.
Okay.
And I am the presenter for Group 1. So my group member will be sharing the screen for me. Okay. Please, can we have the screen now?
Okay, while he's trying to share the screen, I think you can start your presentation because of the time.
Okay.
Yeah.
So intellectual property is a category of property that includes intangible creations of the human intellect. Some of these intangible creations could include your movies, images, pictures. Most of these things have been said before by our mentors. So I'll just be doing a brief recap of what they've said before. Okay. So in business, intellectual property is owned and legally protected by a person or company from outside use or implementation without consent. What this means is that as a business owner, you can protect your brainchild from being used by other persons and other businesses also without your consent. And there are various ways they could use this, your brainchild. They could either use it for themselves, they could either sell it or exploit it generally. Exploitation there has to do with the selling and the use of their personal gain. Okay, moving to the next slide now. How do you intellectually protect a business? As seen before, there are so many types of intellectual properties, but today we'll be talking about just 4, and we'll be talking about patent first. So a patent is a type of intellectual property that gives its owner the legal rights to exclude others from making, using, or selling their intellectual property. This particular paragraph I just read applies to every other type of intellectual property, in that intellectual property, you can protect it from being used by other persons without your consent. Now, there are ways which you can monetize this your intellectual property, which our mentors have said before. You could either sell it off or license it or co-author it. I think that's the word. Yeah, that's the word. So that way you'll be like using it very well, like not like after creating and what's the word now, registering your intellectual property, you just leave it there and let it just remain unused for the period where it can live. Because after that period, it can be transferred to another person, just as we've learned before. Okay, so why should a business register its patent? 1, there's right to legal actions for infringement, right to claim damages, and the court may also grant injunctions restraining an offender from infringement. Our mentor, Mr. Marx, talked about estoppel. With that estoppel, you can apply for an injunction, stopping the other person from using your intellectual property without your consent. You can see in this case, in the case of Bedding Holding Limited and INEC, the INEC was found by the courts to have infringed on the intellectual property of Bedding Holding Limited, and consequently, they were awarded the sum of 17 billion naira damages. So that's one of the basic reasons why you should, what's the word now? Register your intellectual properties. Now, moving quickly to trademarks. A trademark is a visual symbol, word or words legally registered or established by use as representing a company or product. Sorry for the many words. Trademarks there just has to do with words, phrases, which is registered by a business. And those words often phrases, they become exclusive to the use of only that company and that business. Why do people need to register their trademark? Next slide, please. Exclusivity, just as we said before. When you register your trademark, it gives you the exclusive rights to use that trademark only and for yourself. In the case of Apple and Samsung, we saw that Samsung was seen by the court also to have infringed on the intellectual property of Apple. And consequently, they were awarded a $548 million damages for the infringement of their intellectual property. Also, recently, we saw the case of Sabinus, the popular Mr. Funny, on social media. That's his phrase, "something huge is coming," was used by Peak without his consent. And he filed a suit against them. But I think somewhere along the line, it was established that he didn't register the phrase under the, what's the word now? Register the phrase under the appropriate frontier. And consequently, he lost. So it's not just about registering your intellectual property. You must register and register well. So on copyrights, copyright is a type of intellectual property that protects original works of authorship as soon as an author fixes the work in a tangible form of expression. Copyrights covers poems, music, beats, and all. Like recently now, if you listen, there's a particular beat which is called Amapiano. When you hear the beats, you just know that this is Amapiano. Okay. Then why should a company register its copyrights? Okay, they're not registering per se. Yes, no. The Nigerian copyright law, as seen in the Federation of Nigeria, permits the holder to hold a copyrighted work to reproduce the work in any material, form, and publish the work in any way they may see fit. So by this now, when you are using a copyright of another person, you can be sued. And when you are sued, you will pay for it, for the infringement of another person's intellectual property. This next slide, please. Okay, in the case of TV Extra Production Limited and NUC, INEC was seen to have infringed on the plaintiff's intellectual property, and consequently, the courts awarded the damages of 703 million naira. Also, in the case of Paul Allen Oche and Nigerian Breweries PLC, the plaintiff there failed to register, to copyright his intellectual property, and consequently, he lost revenue. So we must be mindful of everything we do as far as it concerns our intellectual property and its registration. Sorry, I'm a little tense. So industrial design. Industrial design is a process of design applied to physical products that will be manufactured by mass production. If we take a look at all these pictures here, you see that's an iPhone. This design is not just produced like in one copy. It is produced in thousands of copies, as well as every other thing there. Now that is the industrial design. Because once we see this phone, we already know it's an iPhone. So that is the industrial design of the iPhone. Okay, so please, next slide. Why individuals or businesses need to register their industrial design? As we've seen before, every other type of intellectual property, they kind of like relate to each other based on this first point now, exclusive rights. Once you register your intellectual property, you have that right of exclusivity to use it for yourself and to use it how you see fit. And with it, you could also generate revenue through the selling, the licensing, and whatever you choose to do with it, as long as it brings money to you. That's the way you can generate revenue from your registered intellectual property. Please, next slide. Okay, in BlackBerry and Typo products there was seen to have infringed on the intellectual property of BlackBerry by using its QWERTY keyboard, the QWERTY, as you see on our keyboard. And they were consequently awarded damages of $860,000. Okay, now in the Tropicana products case, this also has to do with the problem of registration. I think they didn't register appropriately and they lost revenue from it. Okay, so next slide. Sorry. Now, as a concluding thought, in a world where we are big on creativity and new innovations, protecting one's intellectual property could be a means of securing one's future. But unfortunately, many individuals and businesses have suffered loss due to the lack of protection of their IP, and this has occasioned long court cases or complete loss of their IP. We already know that litigation in Nigeria has a very big disadvantage of not concluding early. Imagine a case lingering for more than 16, 20 years. That's a disadvantage already. And imagine that after that 20 years, you still lose the case. So we should be mindful of everything we do as far as our intellectual property is concerned, and we should register appropriately. The knowledge of IP and its applicability is essential for every creativity. In the very competitive society in which we exist, knowledge is power, and the use of such knowledge is wealth. Thank you guys for listening.
Thank you very much, Enifome Ekwa, for that presentation on behalf of Group 1. So I'll be calling on our mentors to give us some comments on the group's presentation and also to make any corrections in the presentation. I'll call on Mr. Marks, if he's still with us, to go first. Mr. Marks.
Yeah, so can you hear me now?
Yes.
Okay, yeah, thank you. So I must first of all start by congratulating both groups. You did a good job, at least for your first week in this mentorship program, and for people who are being newly introduced to the field of IP. Like I always tell people, I always commend younger IP practitioners like yourselves, because for me, my journey in IP was a long journey. I mean, it took me 2-3 years after I had become a lawyer to really even understand the basics of the difference between the types of IP. So I appreciate it when, from a younger experienced age, you're already engaging and, trying to get to know more about IP. So it's a wonderful area. I believe it's one of the areas for the future. If you are looking for an area to specialize, whether you're a lawyer or even you are a business consultant, or you want to go into any of these areas, I think IP is an area that is worthy of giving attention to. I mean, the IP is broad. IP applies in so many industries. In fact, there are some industries that without IP law, those industries will not survive. I say this all the time, and I'll mention some of them. The pharmaceutical industry, for instance, will not survive without IP law, because the pharmaceutical industry is founded on very expensive research and development. So each pharmaceutical company is trying to do research and development to develop new drugs that are more efficient, that work faster, that eliminate side effects, that are safer, for the body and all of that. So it means every pharmaceutical industry is always spending a lot of money on developing new formulas, improving on its existing formula and all of that. And a lot of times that money takes as loan from banks and other third parties. Now, the only way it's going to get return on investment and be able to pay up those loans is by ensuring that at least he has a window of time, that he has a monopoly on the drugs that it manufactures from its unique research and development. So, like Amosa mentioned, I mean, the company has 20 years. So the hope of the law is that within that 20 years, when nobody else is competing with you in the market, you are able to command high prices. You're able to make back enough money to pay off your loans and to also act as an incentive to encourage you to invest in further research and development to get the next breakthrough drugs. You can imagine that without IP law to protect the invention, which is patent law, and of course, trade secrets, how many people will be willing to loan money to a pharmaceutical company, knowing fully well that if I give them money, they develop a new cure, maybe for malaria, for instance. Once they launch that cure for malaria, their competitors would also be able to copy the invention, launch the same competing products. And of course, if the company who got the patent launches and says, okay, we are selling each tablet of our new breakthrough drugs for 10,000 naira, it means the competitor can come into the market and try to undercut them and say, look, we'll sell us for 9,000 naira. Then it means that the main person has to now come down to that 9,000 or maybe 8,000 to be able to match the competitor in the market. So that would mean its profit share would really be reduced. So you can imagine how bad that would be for that industry. Another industry also that can no longer survive without intellectual property law is entertainment and recreation. So sports, for instance. Now, the traditional way sport companies make money, football clubs, for instance, the traditional way they make money from putting on live football games is by ticket sales. So people buy tickets to come into the stadiums to watch the football matches. But imagine, if any football club is only banking on that, then that football club is losing a lot of revenue, because the greater chunk of money that football clubs make now is no longer from sale of tickets, it's from sale of jerseys. So you hear things like the moment Ronaldo was signed by Al Nassr, the club in Saudi Arabia, within barely 24 hours, that club, their social media following, multiplied in multiples of 10,000. As in, I think the social media page, I don't have the exact figures now, but maybe something like 10,000. Immediately Ronaldo signed, it jumped up to 10 million immediately. So you can imagine how much more they will make, even from advertisements on their social media page alone. Not talk of the sale of his shirts. I remember when I think Ronaldo was signed by Real Madrid, the money they signed him from Manchester United, they made it in just sale of his jerseys in barely 48 hours. So it tells you that there are new ways. And of course, how is that possible? That's because of of how IP law allows for merchandising, for licensing and other things that surround merchandising of articles. So it tells you that this is another industry that if you do not have a sound IP law framework, you will not make it in the sports. And of course, we talk of entertainment as well. Licensing of musical works, of video, you could make a movie, the movie succeeds, and you license it to somebody to now make the video game version of that movie. You could actually make more money from that video game than you made from sale of the movie itself. So that's another industry. And then of course, a third industry where the industry will not survive without intellectual property is technology. So technology runs on intellectual property because the backbone of technology is software, and software is governed by copyright. So without that framework of copyright and the ability to license your software, you will not be able to make any progress in the technology space. So you can see these are three huge industries that IP plays a fundamental role. So it means you can look at any of these industries, and there are so many others, but these are just 3 prime industries. You can look at them and choose to even focus your quest to become an IP practitioner in those areas, and you would be home and dry. So having said that as just a broad framework, I'll just touch quickly on a few things I would want to mention from a presentation. So I'll start with group 2. Yeah, I saw group 2, I saw your slides, and I thought they were really good. I mean, I commend you for that. I loved how the slides really hit a lot of the high points, and how they were brief, but yet very expansive in terms of covering the full range of the field. Just a few things I would want to mention. Now, I love what the presenter kept hammering on, the fact that IP is an asset. So she kept saying things like license your IP asset and all that. I love that fact. For IP and business is one area that people have missed for a long time, but IP, intellectual property, is an asset. Before this time, like I told you, people used to classify intellectual property as a liability on the books of accounts of a business, because the idea was that, and why they thought so was that when you register a trademark, each year, like in Nigeria law, for the first 7 years, your trademark is valid. After that, you have to renew it every 14 years. For patents, you have to pay annual renewal payments for the 20 years that your patent lasts. So because of that, formally, business people and accountants saw IP as a liability, something you have to maintain every year. You have to be paying money to maintain, regularly and all of that. So it was viewed as a liability in the what they call now the balance sheet of a business. But new thinking has now said no, IP is not a liability; it's an asset. It is there to add value to the business and to increase return on investment. So you can see that it's very important to have that at the back of your mind as an IP practitioner, as you go out to begin to advise businesses, to make them see that your IP, registering your trademark, is not a liability, it's an asset. Because by registering your trademark, you can choose to say, look, I operate in Abuja alone, but somebody in Lagos seems to have a lot of interest in my brand. I license to them. Now I'm making money from Lagos that I would not have made except I had registered my trademark, and I'm able to license that trademark for somebody else to use in Lagos. So you can see that it becomes it becomes something you can classify as an asset, because it's helping to bring return on investment. So I wanted to just commend you on that. That's a very important point you struck on in your presentation. Then another important point also the presenter for Group 2 mentioned was that licensing can be fractional. That means licensing can be done in bits and pieces. So I'll give a classic example now for copyright. When it comes to copyright, you can grant even 10,000 people a license of one copyright work. And that is because copyright itself is a bundle of rights. So for instance, one music, the lyrics of that music is considered to be literary work. That's just the lyrics now, without the musical part of it. It's considered to be literary work. So even that music alone, the lyrics alone, can be licensed to different people in different parts of the world. So you can license to one person to use the lyrics only in America. You can license another person to do that in Brazil, in China, and in other parts of the world. Now, the composition of the music itself, which is the melody and how the music flows, the harmony of the music and all, is considered as musical work. You can license that separately. You can license that music now for somebody to use in what we call a synchronization agreement, use as part to accompany a movie soundtrack. That could be one way of licensing it. You could license for somebody to use only for purpose of performing live performances in Japan. So you can see that you can license a broad spectrum, same right, the same song, but different licenses can be given, and you're making money from all those different licensing. So that's also another important thing. And of course, you mentioned rightly that when it comes to franchise, what franchising does that, it puts a bundle of IP rights together. Essentially, what you are doing in franchise, what we call business format. You are giving your business format to somebody to use. That is all your different modules of the way you operate your business, including your trademarks, your brand, how the business looks, even what we call trade dress. Trade dress is how your inside of your shop looks, the colors you use, and the different elements of decoration you use within your shop space. You can license all of that along with your patents, with your for instance, with somebody, the presenter mentioned McDonald's. So when McDonald's gives you a franchise, it's a bundle of things: the McDonald's logo, the McDonald's name, the trade dress of how the McDonald's front of the shop looks and how the inside of the shop looks, the uniform of the staff, the menu list, which will be copyright, the secret formula for how they prepare their marinate their chicken, for instance, will be part of that bundle of rights that is licensed under the franchising agreement. So that's also important to make that distinction. Now, when it comes to franchise, it's a bundle of rights, but licensing can be done in segments and in fractions. And then finally, I wanted to also just point out something. When the presenter talked about trade secrets and confidential information, it's also important to know that trade secret and confidential information sometimes can be very mundane information, regular thing. It doesn't have to be anything special and high and mighty. That is the difference between trade secrets and patents. When it comes to patent, it must be an invention. An invention, of course, has a definition in law, is a new or improved solution to a technical challenge. So it's a very, and then of course, there are elements you have to prove before it qualifies. It has to be novel, it has to have industrial application, it must show, it must disclose an inventive step, essentially meaning that it's not something that is already commonly known, but I don't want to go into much of that. Just to mention that the difference between patents and trade secrets, that trade secret can be something that is not a very unique thing. It's not new, it's not novel, it's not anything high and mighty. Regular things like phone number of your customers, for instance, is a trade secret, because if somebody is able to get the full customer list, all the phone number of your customers, he can begin to send messages to them and pretend to be you and steal a lot of your customers. So as regular as that is, list of your suppliers, for instance, also another important thing, because part of what gives your business the advantage is that maybe you know where to buy your oranges at a cheaper price, so that when you bring them into Abuja or Lagos and you sell your smoothies, you're able to sell your smoothies for 1,000 naira, whereas others are buying at a place where if they sell to make a profit, they have to sell at 1,200 naira. So it means if somebody can get a hold of the phone number of the person who supplies you orange, maybe from somewhere really far away in Benue, then it means that that person has eroded your competitive advantage in the market. So when it comes to confidential, trade secret and confidential information, they can be very regular, mundane things. It's not anything high and mighty. Anything at all that gives an advantage to your business in the marketplace is worthy of being protected as trade secrets or confidential information. Of course, the presenter rightly mentioned that for you to get that protection, you must show that you're actually keeping it secret, because unlike patents, if a person gets your product and does reverse engineering, that means he takes the product, he studies it, and then he learns how you invented it and he begins to multiply it. You can still get an injunction and stop him from doing that. Your patent stops anybody anyhow from using that invention, whether the person on his own sat and even also the way you came about the invention, he also invented it independently without looking at your patented work or copying your product. Yet once you have a patent, it's a monopoly that stops anybody from using that same invention. But when it comes to trade secrets, if a person can sit down and figure out how you came about a particular invention or a particular trade secret, then the person will not be stopped. The only time you can stop a person from using a trade secret is where it is shown that the person actually stole your secret. And that means after you have put measures in place to prevent anybody from getting access to that confidential information, the person still somehow managed to get access to it, unlawfully. That is the only time you are protected. So that's one distinction you must make between patents and trade secrets. Then for group one, yeah, I also loved your presentation. It was, some of the basics, you taught some of the basics, but I thought there are a few things that you might not have gotten too clearly, for group one. So one of the things I thought I think I had mentioned that is that you must understand that when it comes to the different types of IP and how they relate with businesses, it's not always very clear cut. So one product can have all the different IP rights in it. So for instance, if I'll give an example of a typical product, say a phone, for instance, the software that drives that phone is protected by copyright. Maybe the type of glass used to make that phone is a type of glass that even if it falls, it doesn't break because it has a special chemical formulation. That would be a patent. That could be protected by patent. The name of the phone, the logo of the phone could be protected by trademark. Now, it could be possible that the unique shape of the phone and the colors of the phone that makes it really attractive, that could be protected by industrial designs. And then it's possible that you have a particular unique liquid for a formula that you can use to wipe that screen that keeps the screen always looking good. That you could decide not to protect by patent, but protect by trade secret. So you can see that one product has many different aspects of intellectual property, protecting it all at the same time. Then there was a case you mentioned. I wanted to just make a clarity also on that case. The case of Paul Allen. I was actually involved in that case at some stage of the case, though I didn't. I drew before the case got to judgment. Now the judgment of that case is I want to just make that point that it's quite unfortunate. What the Federal High Court held in that case was that Mr. Paul Allen could not benefit, could not enforce his copyright because he did not register the copyright. Which, if you listen when Amusa was speaking, is clear that the judge was wrong on that footing. Copyright arises automatically upon creation of the work. You don't have to register your copyright before you can enforce it. The moment you have fixed it in a medium, and fixation simply means that you have put that work into a medium that other human beings can enjoy it from. So if it's a written work, the moment I write it down, if it's a novel, the moment I write it, even the handwritten manuscript, automatically the copyright protection arises automatically. If it's a song, the moment I record it in my phone, record it, in a studio anywhere else, automatically that arises. If it's a painting, the moment I draw it, it arises. Now there are some more detailed questions which I'm sure you get to as you get into your mentorship. What of things like tattoo written on the body? Would that be copyright? Will it not be? So I'll leave that for now. But as you go in, that's a question you should allow your mind to think upon. But Paul Allen's decision was wrong. You don't have to register copyright before you can enforce it. For trademarks, you have to register it. If you do not register your trademarks, you can fall back on the law of passing off if you have not registered your trademark. For patents, you must register. If you do not register your patent and you disclose it to the public, you lose the right to register it. So that's one important thing you should note. Patents and industrial designs. Once you do not register them, so you see the three different ranges now. For copyright, you do not need to register before you enjoy it. For trademark, you may register, you may not. If you do not register, you can still come under the law of passing off. And you can always register it after your sales. Even if you have used it for 20 years, you can still come and register it. But for patents, you must register it before you put it into the market. The moment you put it into the market without registration, you lose the right to register it forever. So it means you have lost it completely. So these are the three different spectrums. Always note that, that for copyright, you do not need to register. For trademarks, you may register, you may not, but it's advisable. And I must have mentioned that for copyright, even though there's no requirement for you to register it, however, there's a voluntary deposit you can do at the Copyright Commission that makes it easy for you to prove when you produced or when you came up with that creative work. However, it's not mandatory. So without registration, you are good to go. But for trademarks, if you want to benefit from the Trademarks Act, then you must register. If you do not, then you have to go under what we call the law of passing off. And law of passing off is more difficult to prove because you have to prove your goodwill and so many other things to succeed, in that line. But for patents, you have to advise your clients, you must register. You cannot say, I've invented this new product, let me go and test it in the market. If it succeeds, then I'll come and patent it. It will be too late by the time you have tested it in the market. The only way to protect yourself is if you want to share your patented invention, maybe with third parties like funders, like maybe a bank that wants to fund you. You now have to share to them under a non-disclosure agreement. That is the only time that you still have the right to come back to patent, to register the patent, even after disclosing the invention to third parties. So it's important to just have that at the back of your mind. So thank you. I know I've overshot my time, so thank you very much. That will be all my comments for now. Thank you.
Thank you very much, Mr. Mines. Sorry for the I think that was very good. We learned from the mistakes on the presentation. I took down all the corrections you made. So I'll be calling on Ms. Amusa to also give us her comments on the two groups presentation before we move to the question and answer session.
Okay, so not to take much of our time, Mr. Marks has done a very good job already, so I don't think I'll be commenting.
We can't hear you, ma'am.
Oh, can you hear me?
No, we still can't hear you. Can we
Someone
hear?
said yes.
Yes, ma'am.
Maybe it's your network, Hussein.
Okay, I can hear you now.
Okay, I'll say not to take much of our time. Mr. Mark has already covered majority of it, so I think we just go to the question and answer. There's nothing much to discuss.
Okay. Thank you very much. So before the question and answer session, please kindly we encourage everybody to put on their videos. We want to take screenshots for social media. You know, we have to post and write what we've learned about the session. So please put on a smiley face for the camera. Okay. So please, if your video is not on, kindly do so in just 60 seconds. I'm seeing somebody's free, Joe. Please, it's your face that we want to see. All right. Okay, thank you very much. I think I got some screenshots, so we are good to go. Okay, so I'll be pasting the questions from mentees to mentor on the chat box and reading it out for our mentors to answer. So the first question is, there seems to be a thin line between some of the aspects of intellectual property like trademark, patents, industrial design. How does one determine which to do at every point in time? Or would one just do all that the intellectual property work falls under? I think most of these questions have already been answered by Mr. Mark, so I'll just give Ms. Amosa to just throw more light on that.
Okay, so to answer this question, like I said, you have to determine the type of work you're doing or the type of work you want to protect first and understand under what class, like the best class for you to be protected in. Then look at the number of years. Like, so, for example, now trademark and industrial design, they can kind of be substituted. So look at what exactly the rights or whatever it is you want to protect. Are you looking at a long-term goal or a short-term goal? Then, for example, now in the fashion industry, most times some of them come up with a sketch before they come up with the main design itself in the market. So your sketch, for example, now you can have that protected under copyright. When you now have that work mass produced in the market, you now have to protect that mass produced work under industrial design. So it depends on the stage you are in. Do you understand? So once your brand is improving or based on how you are going, you can start protecting this thing. Then for patent as well, sometimes not all inventions usually have inventive step. So once your invention does not have inventive step, just go under utility model. It's still a type of patent, but like a smaller patent. So instead of using the main patent, you put yourself under the utility model, which is for 10 years, unlike patent. Patent is 7 years, utility model is 10 years. So it depends on what exactly it is you are doing. So don't just advise your clients based on what you know about IP. You have to ask them questions. You can't just tell them do this without asking questions. It's very important for you to ask questions. Ask questions, has it been published? When did you produce it? When do you do this? When do you do that? Do you do search, for example? Some people don't do trademark search, and trademark search is very important. Once you don't do trademark search, it's possible you might have opposition later in future from somebody else that has similar trademark as yours. So all of these things, you have to do them, follow the process, don't jump lines. Yeah.
Okay, thank you very much, Ms. Amosa, for answering that question so wonderfully. I'll be calling Mr. Marks to answer question number 2, which is, okay. What's the significant difference between industrial design and patent, because they are almost always interwoven?
Yeah, thank you. That's a very good question, and thankfully also has a very simple answer. Now, always note these 2 words in your mind when you are approaching the difference between patents and design. One is about utility. That is the function that it serves. That is patent. So patent is about function, while industrial design is about the look and feel, or what we call the aesthetics. So for it to qualify as industrial design, it must be a feature on the product that does not add to its function, but only adds to make it more appealing to the eye. That is what industrial design protects. That if you have a unique, whether two-dimensional or three-dimensional feature on a product, so it could be colors, it could be line, but anything that makes the product catchy to the eye and makes people attracted to it, that is what industrial design covers. But patent is about functionality. So what is that new inventive function that this product has that nobody else has put in the product before? Then there's also what we call process patent. So what I described initially is now is a utility patent, but there's also process patent. So a new or improved way of achieving a technical result could also be a patent. So I'll give a practical example. For instance, when it comes to usefulness, the patents that are for use, for instance, an electric iron, you can use it to iron. But if you want to get a more clean finish to your iron, you may want to use your hand to sprinkle water on the piece of cloth in your ironing just to stretch it out, and the steam from that water makes it better. Now, when somebody now sat and looked at that person and said, look, how can we make this better? Instead of having to get a bowl of water, or what if we put a container right inside the electric iron and put some vents that this water can come out through based on how you control it with a switch. So you can see that the steam iron is an improvement on existing iron. So that is a function, that's a functionality. But that steam iron, the way you design the handle, the way you curve the handle, for instance, now the handle doesn't really add to the function, or maybe sometimes the handle may, because it may, but not almost always the handle doesn't add to the function. It's just about making it look finer. So that is an industrial design. Whereas the handle, the color of the handle and all of that is an industrial design because it makes it attractive. Whereas the vents and the way the steam comes out and the way the container is integrated into the steam iron is about the function. So that shows you a clear difference between function and aesthetics or look and feel. So that's essentially the difference between industrial. But for the requirements, they all have to be, they have to be new. They have to have something unique about them, and they have to have industrial application. So the speaker mentioned about the fact that it's something you use to multiply, and you can use it as a to make that same product many times, giving it the same unique look and feel. I hope that answers the question.
Thank you very much, Mr. Max.
Let me throw in more light in that as well.
Okay.
So in some cases, some products can have both utility, can have both industrial design and patents, just like Mr. Max has mentioned. So don't just say that because this is not industrial design, it can't have patents. No, you can have industrial design and you can have patent. So recently, I saw a pen with a student. This pen has two sides. I don't know if Mr. Max saw it. I put it on my WhatsApp.
Yes.
Yeah, it has two sides. So the ink is very tiny like this, and underneath it you have bubbles for children. You just open it and put it in the bubbles and just for children, but it's still a pen. So that's a patent and an industrial design on its own. Although the person that did the design is not the owner of the patent to the biro, right? But the biro has already elapsed and the patent is already in the public domain, so anybody can now use it. But that design itself will be protected under industrial design. But you might not have a right to the patent, but you have a right to the industrial design. Also look at when AC first came in, I have a friend who was like, this fridge is very beautiful. Meanwhile, it was AC. Do you get? So that AC, the beautification itself is industrial design, but how it works is patent. How it works is patent. So patent only protect the aesthetics, how beautiful it is. If you have something that is functional, it has no industrial design. Industrial design is just how beautiful it is, what attracts you to buy that product. Why the patent is the functionality. And like Mr. Mark said, your patent could be a product, it could be a process, it could be an equipment. So you can have a product by process, you can have a process, and you can have a product as well. So that's just different between patent and industrial design.
Thank you very much, Ms. Amosa, for the contribution and more explanation on that question. So I'll be taking the next question from Ms. Amusa, which is question number 3. What is the difference between IP licensing and IP franchising?
I understand this can be clumsy sometimes, but IP franchising, like Max said, is as if you are giving out all your model, your design, your trademark, recipe, and all of that. It's not just only your trademark, it's not just one thing of your IP. It's like you're giving out a bulk of your IP as a model. I don't know if you can hear me because it's showing my network is a bit fluctuating.
We can hear you.
Can you hear me?
Yes.
Okay, so the franchising is like you are giving out all your models. I don't know if you've seen this movie, the McDonald's. Is it McDonald's? I can't even remember again. There's this documentary on how he lost his right legs of it. So it's like your trademark, your trade dress, your recipe, you are giving them just like that. So they are following the same process you are following. In every branch you go to, everything they are doing has to be the same thing. That's a license, that's how franchise works. But license, can say, okay, I'm giving you only my trademark. I'm giving just the person my trademark. It could be exclusive, it could be non-exclusive. You can even cross-license. You can say, take my own, give me your own. We won't be paying each other, but use my own, me too, I will use your own. So it depends on the agreement, how far you want to use it, which country, which states, and all of that.
All right, thank you very much for answering that question as simple as that and making it more understandable. Okay, I'll be asking the second to the last question, which is for Mr. Marks. What constitutes the public in the disclosure of trade secrets?
Okay, yeah, thank you for that question. So the public simply means any other person apart from you yourself. So when it comes to patents or trade secrets, is the same measure. And why this question is important is that this question sometimes boils down to the issue of in what name you want to register your IP. So you can register a patent in the name of an individual. You can also register that patent in the name of an organization. So if a patent belongs to an organization, which is another topic I'm sure you get to, about when employees in employment invent or produce IP works, who owns it. So that's another topic for another day. But however, sometimes for strategic reasons, you might, because of your trade secret policy, want to always create ownership of your IP works in the company to ensure that if information is disclosed within the company and maybe with close advisors, consultants, professional advisors, lawyers, accountants to the company, then there's no disclosure to the public. But like I said, the safest way to avoid falling, asking yourself this question is every time you are giving your IP, particularly trade secrets and patent to anybody apart from yourself, always make sure that it's under the obligation of non-disclosure. So there should be a non-disclosure agreement to ensure that the law would say that so far as the information was given out to the public under confidence, therefore there was no disclosure to the public. Otherwise, once information is given to third parties without an obligation of non-disclosure or confidentiality, it means you have disclosed that information to the public. Of course, there are exceptions. So, for instance, for patents, if you disclose it in technical forums such as trade fairs and maybe academic publications and all that, within 6 months before you register, you are still covered. But if it exceeds that 6 months, then you lose the right to be able to get that protection. Now, one last point also on this issue of whether to register your IP in the name of your company or the name of the individual. Another important point to note is that for copyrights, why people prefer to register copyrights in the name of human beings rather than organizations is that you get a longer protection. So if I write a novel, or assuming my law firm produces a book on intellectual property law, if we choose to signify that that copyright belongs to the law firm because it was written collectively by the members of the law firm, then we would only get 50 years of protection. But if I choose to indicate that this book was written by myself and I license it to my law firm or transfer or assign it to my law firm, and the law firm now markets it, then it means that what we'll be getting will be the duration of my lifetime, and then 70 years after I die. So it's a longer protection than if you just do it directly. So it's important in book publishing industry. That is why book publishers would get you to first register the copyright in your name, then you assign it to your publication company, who now does the work of putting money into producing the books and selling it out there. That way they get the full. So for instance, Chinua Achebe died, I believe, in 2012. So it will take another 70 years from 2012 before his books, Things Fall Apart, come into public domain where anybody can use it. Thank you.
Thank you very much, sir. I'll be taking the last question, and if any mentee has a question, you can indicate by raising your hand, and I will call on you to ask your question directly to either of the mentors. So the last question for Ms. Amosa: briefly explain the concept of parallel imports under IP in exports.
Who asked this question, number one?
That's
Because for somebody to ask this type of question, it means you've read. So when you talk about parallel imports, although some people don't buy the idea of parallel imports, because parallel imports and exhaustion of rights, they are kind of interwoven. So we say exhaustion of rights is when you must have made money from your IP. That means any other person using it other than that period does not need your authorization. So as long as you've made money from your IP, every other person are free to use it without infringing on your rights. So that's what exhaustion of rights actually means. But people don't like that idea. Like, why will you tell me my IP will expire once I've made money? And I still have this so tenure for it to go to the public domain. You're not saying once I've made money, somebody else can use it without my permission. So that's parallel import, and it's just somehow. But anyway, parallel import is like, okay, fine. And it depends on the reciprocity of these countries. For a country to actually allow parallel import, the other country that we are importing it must have that same law in their own country. So you can't do parallel imports in a country that does not have that law in their own jurisdiction. So parallel import is like, okay, fine. We've sold this product and it's going out, but our trademark is still there. You don't have the right to remove the trademark and put another wrapper around it without putting that person that owns its name, even though you are going to sell this product without our permission. But our trademark or our branding has to remain on it. Do you get it? But some people try to like misuse that law, and they are going to take another wrapper or another packaging to package that product. They are selling a different company product, but they've removed their own packaging. Now repackage this in another packaging, but it's still that same company's product. Even though you don't want to get authorization, it's okay for their brand to still be out there without getting authorization, and you're still making your own money. But don't rob them off of that visibility of their own brand because you don't want to put them out there. You want to put another brand. So you now have to put a different brand on an original product, a fake brand or a fake branding on another person's product, even though they're not taking you out for copyright infringement. So irrespective of the fact that you've exhausted your rights or you are under parallel import, the original branding or packaging still has to be there. So that's all parallel import is really all about.
Thank you very much, Ms. Amusa. Any other mentee that has question, please indicate by raising up your hand. With this, we've come to the end of the program. I say a very big thank you to Mr. Marks for joining us. We saw that he's having a very busy day. The first time he talked, he was on the road. The next time he just teleports to the office. I don't know how that happened. So, thank you very much for joining us today, Ms.
IP exporting.
Thank you very much. Also, if you are not following Ms. Amusa on LinkedIn and on Instagram, you are missing a lot. She always drops informative content. She always drop anytime you just go and you want to watch status, you must see her own face. I'll be like, is it every time I'm with them? I want to come and play. I don't want to learn every time. And you must always see her content. And you must always learn something.
Right, you see the memes, the playing memes.
Yes. Yeah, you see everything. So they are all there on LinkedIn and on Facebook, Instagram. Sorry. Yeah, LinkedIn and on Instagram. What's the handle again? The intangible
nuggets.
Yeah. So thank you very much, all the group members for your.
So I'm sorry, just a quick one. So I understand that this presentation actually made everybody work, but it shouldn't end here. If you actually want to learn IP, you cannot just do it one day and stop. You have to continue, keep learning. So majority might not know about WIPO. Like WIPO is like the platform where everybody gets free knowledge. Although there are some advanced courses, but before you get to that advanced stage, at least you should have an idea of the DL 101 and the likes. So you can just sign up for WIPO courses as well.
Okay, thank you very much. With regards to that, we are coming to the end of the program. Thank you very much, all the group members. Great work for the first week of the mentorship program. There are more works coming, more interesting topics, more interactive topics, and more mentors are coming on board. So please sit tight and always complete any task I send on your WhatsApp group, because if you do not complete it, I'll be on your neck. So bye-bye, everybody. Have a fun-filled weekend and enjoy yourself.
Bye-bye. Have a wonderful evening.
Okay, thank you. Bye, guys. Have a great weekend and see you again soon.